Please be advised that this podcast was made for fun and to share the general experiences of two criminal lawyers in Toronto. You must not take anything you hear in this episode as legal advice. Every situation for every person is different, and you should always consult with a lawyer for legal advice specific to you and your circumstances. Hello. Welcome back to Justice Redefined, brought to you by Titan Defence LLP. I'm Sina Shabestary, partner and criminal defense lawyer at Titan LLP, and we are taping this episode from our fresh new location at 778 College.
And it's Kabir Sharma here, partner at Titan Defence LLP. Today we're joined by Sherif Foda, criminal defense lawyer. Sherif, what's your law firm called? Foda Law?
Sharif Foda Law Professional Corporation. Sometimes people just call me Foda Law, so I've kind of been adopting that. But it's just, I'm not a serious operation, so I don't really care.
That's not true. We're absolutely stoked to have you here, man.
And before we forget, we're also joined today by our producer, Kazra.
Yep.
Thank you so much, Kazra, for making this happen, setting everything up for us, and doing our post-production and editing. Kazra is a G. Thank you so much. So and let's get started. What are we talking about today?
Today's episode is going to be on wiretaps and wiretap investigations, but and who better to talk about that than Mr.
The king of wiretaps?
I don't know about that. King of wiretaps, maybe I'm caught on a few myself.
Who isn't?
Yeah. My God.
Yeah, absolutely. When you
They'd be disgusted if they heard my phone conversations.
Yeah, exactly. And that's why I think it's such an interesting topic. It's just imagine, I think you have such a high expectation of privacy when you're talking about wiretaps. But before we get there, Sharif, tell us a little bit about yourself, your background. Where'd you go to school?
I went to school at Ottawa U. I actually did civil law, which is the Quebec kind of version of law. Quebec law schools, they have a civil law system as opposed to common law. That's for everything except for constitutional and criminal law. So they're private law, so contracts, torts, all that kind of stuff. It's a different legal system that's based off of the French civil code. So in order to practice in Quebec, you need a civil law degree. I, at one time, thought I was going to practice in Quebec. I did my civil law degree, followed by a common law degree, national program at Ottawa U. I did some further studies, did a master's, articled, clerked, and
what did you do your master's in?
Law and finance.
Law and finance.
Yeah.
Huh? Wow. Yeah, quite the change.
Yeah, man, you come a ways.
Well, it's still useful and relevant to me today, and I'm very glad that I did it. It gave me insight into capitalism and the business world.
Right.
Mm-hmm. And it also, even if you defend people charged with Securities Act violations and things like that, having an understanding of the capital markets is useful. But I think that I got a bit disenfranchised with my ability to actually practice in terms of litigating
Mm-hmm.
in securities work in Canada. You don't get in court a lot. And ultimately, when I was clerking, I decided, really after getting advice from a lot of people, that sort of litigation was what I wanted to do. And in order to do that, you have to you have to get the reps in. And you can only really get the reps in, I think, in criminal law, maybe immigration, maybe family. But it fit for what I wanted to do, and then I haven't looked back since. So I went to Ottawa U, did that master's, and then after my articling, I decided I wanted to go to Toronto. Had some personal circumstances at the time, and I've been in Toronto since 2014. Practiced for a year at a small boutique. Wasn't sort of thrown in court like most criminal lawyers are when they start off. Mm-hmm. So I'm sure you have your associate Kay Vaughn, who I'm sure was thrown in court right from the beginning. That was very different than my first experience. Yeah. Mm-hmm. So after about a year, I went to another small firm, worked there for 3 years, and went out on my own. So since 2018, let me just think. Yeah, I think 2018, I went out on my own. And then a couple years ago, I hired an associate. He's great, Rick Frank, and we practice together, have a small practice.
What do you mainly focus on in terms of the type of offenses that you defend?
So I would consider myself to have a general criminal practice. I don't restrict my practice to any particular type of offenses, but it's just so happened that a lot of my experience has been in what we call, like street crime stuff. And that is often, believe it or not, criminal organizations, because they're usually street gangs, right?
Yeah, most of the time.
And so
Drugs and firearms, basically. Yeah.
exactly, drugs and guns, and
Violent offenses, you do
yeah,
yeah.
the range from domestic assault to murder to impaired driving to fraud.
What are your favorite type of cases to defend? How about that?
Oh man, favorite type of cases. I don't know if I have a favorite type of case. I know what cases I don't like doing because they're so stressful and difficult.
Like
Sexual assault.
Yeah.
Just,
Those are hard.
I would say, really since the new legislative changes that have been implemented in the last couple of years, our response to social problems and an acknowledgement that we should have about the treatment of marginalized people in society, in particular women and racialized people, have led the Liberals to, I think, be a bit overzealous in their legislative response. And their recent amendments to specifically the regime regarding sexual assault litigation. I mean, I'm not the first or the last to say this. It was brutal. It's like they didn't consult anyone who actually litigates, crowns or defense lawyers, because now I think on both sides of the bar, it is just so exhausting.
Yeah. It was a direct response to the Gomeshi trial.
Yeah.
Am I right?
I think so.
I think so too.
People called it like the Gomeshi bill.
That's it. Yeah.
Right?
I don't think that's a
and
secret.
And maybe for those of you that don't know what we're talking about, basically what happens now is that if you have communications between the accused person who's charged and the complainant or alleged victim of an offense, that you need to disclose those emails and messages to the complainant. So basically, they know you can't really, it's called impeaching their credibility with documentation. So basically what the defense lawyers are worried about is that they'll tailor their evidence to accord with whatever information that they've seen. So you can't really surprise them and catch them in a lie.
Yeah, that's according to like the most conservative interpretation of one particular provision.
Yeah.
It says they have a reasonable expectation of privacy in these communications. And so,
But they're privy to them.
yeah, I know. And so right now we're kind of in a bit of a limbo because the Supreme Court's sitting on a constitutional challenge, and that I think is likely to change the regime. But so it's just so procedurally complex that those cases for me are not really fun anymore. I also get daunted by frauds.
Yeah.
Believe it or not, I don't love frauds because of how intensive they are in terms of the amount of disclosure review that come with them, these data dumps. And I'm actually really, as much as I used to love the big wiretap investigations, the criminal organization cases now, I find at this stage of my career, I'm starting to resent how we don't have the resources to really challenge them effectively because of how these investigations are changing, how the wires are getting bigger and bigger, how there are more and more investigations that sort of predate the wire. And that means that you have to, in order to challenge a wiretap, sometimes you have to go back into documents that date back like over 20 years. And there's people don't understand these are thousands and thousands and thousands and thousands of pages of disclosure, followed by sometimes a like 4,000 page wiretap application. So the warrant itself, just to read that, takes weeks. And they build on each other, right? Because when they have, we're seeing now more and more in these wiretap applications it's like, oh, and this person was a target in this investigation, this prior investigation, like 10 years ago. And it's like, okay, well, what happened in that case? And they are targeting more and more people. So I am resenting how ineffective I am in being able to challenge the lawfulness of these intercepts. And so
I feel like basically it's once a wiretap warrant is signed, it's basically a ticket for a conviction in a lot of cases, right? Like, wouldn't you say that?
Well, I think in large part it has to do with the resources that we're faced to, which is exactly what you're saying. The vast majority, first of all, it's a very high threshold to challenge them. And second of all, it takes a lot of effort, and a lot of lawyers who are dealing with that on legal aid certificates don't have the resources that they need to challenge them properly, which is like a question I wanted to ask you when you talked about the appreciation of like capitalism, your background that it gave you. Is it because of the inequities that are involved in the criminal justice system generally?
Yeah, I think if you practice criminal defense, you start disliking or resenting sort of the state structures that oppress people. And we are able to see more and more how intertwined capitalism is with the criminal justice system. Of course. And so it gives you, I think, the human insight into why poor people are more likely to be on the wrong side of the criminal justice system,
right?
And how the systemic social disadvantages and problems with our economic systems lead directly to the criminal courts. It's a pipeline. We hear the expression the school to prison pipeline. It's also the poverty to prison pipeline, right?
I think it's like it's amazing when like you talk about the legislatures and like the laws that are in place. As soon as their privacy interests become at play and they're threatened with losing their privacy, then shit really changes quickly. But when it comes to the general masses, that's not the case. So let's get into it. Why don't we kind of simplify what it is we're talking about here? What are wiretap investigations?
First of all, like what's I think like the proper term is intercepted communications.
Right. Yeah.
So like, can you explain, in your opinion, what intercepted communications are based on the law and your knowledge?
Yeah. So private communications are what normal people, what regular citizens or residents would consider to be private conversations. So usually over the phone. So traditionally, we've had phones for a long time now. So those oral communications, but also text messages. Mm-hmm. So SMS-based text messages. Also like chats via... there's a case from several years ago where the police had applied the wiretap to, you guys remember MSN Messenger?
Yeah.
MSN Messenger. Those are also private communications. Right. And I think they would extend to any social media app-based communications as well.
Right. What about things like WhatsApp?
Yeah.
Yep.
Okay.
Yeah. Apply to
WhatsApp.
What
does the encryption not matter on like the channel for the intercepted communication?
So we're talking, when you ask that question, there's two parts to that. One is does the warrant legally allow the police to intercept them? Mm-hmm. And two is, are they able to with the technology? And the answer to the first question is yes. The answer to the second really depends on the technology that you're using.
And if it's no, then what? If they can't? If they're unable to, are there further measures that they can take in order to get them, or is it just bunk?
Well, it depends on the specific technology, right? Like there's very few technologies that are that are difficult for authorities to actually intercept.
Right.
And even then, there are methods that the police often use, like workarounds, to try to get access to those communications. Like, for example, let's say you use the best messaging app in terms of security
and encryption.
And it's not stored on a server.
Like Telegram, Signal, Wicker.
Yeah, exactly.
Yeah.
But what if they seize your phone and they get into your actual physical device?
Right.
Those messages are often stored there, so they can get them like that. Right. And what we're seeing now in some of the more recent wiretap warrants is sort of secretive technology that they call ODIT. ODIT, on-device install technology. So it's like an app that the authorities like install on your phone that gives them like access to everything. So it's like your phone is like a spy device. They can turn the mic on and record you without you knowing. They can turn the camera on.
Is it one of those things where they'll like fake arrest you and then they'll take your phone from you and then they'll install it and they'll give your phone back to you and say, oops, like you made a mistake, you can go now?
They probably can do that, but they also, I think they do it remotely.
Oh, wow.
Oh, wow.
Yeah.
That's crazy.
Like they can install an app on your phone remotely without ever even touching your phone?
Yeah.
Holy shit.
So let's back it up a bit, okay? A crime is either committed or is understood to be committed or suspected, whatever, okay? A police officer who is drafting what we call an ITO, which is an information to obtain a warrant, is drafting a document so that they can take that to the judge to sign and so that they can get the warrant that they want. What is happening? Like, what do they need to put in there? What's the legal threshold?
Okay. Can I pause though and just say,
Sure.
No, and I'm not trying to say pause the podcast. I'm saying let's pause and just think of what do we know about wiretap investigations? The best, I think, show that people can watch
The Wire
is The Wire.
100%.
It's such a good show,
Yes.
and it's actually realistic. If you look at what they talk about in the show in terms of how you build a wiretap application and the technologies that they use.
The omnibus,
It takes
Well,
years to like build a case like that sometimes, right? Like a wiretap investigation.
Sometimes, sometimes in months. It really depends on the nature of the investigation and what you're doing. But the show The Wire is a great introduction into how wiretaps like work. Also, like bear in mind that that's the American context. It's actually not much different than the Canadian context. But basically, in Canada, in order to intercept someone's private communications, you have to have judicial authorization. Judicial authorization means a warrant. That means that the police can't just do it without asking a judge to authorize it. They have to go to if it's what we call a Part 6, which is a wiretap is a Part 6 of the Criminal Code. That has to be signed off by a Superior Court judge. So they have to go to a Superior Court judge and submit a document where they say these are the reasons why we want to start listening in on this guy's or these people's phone calls. And there are conditions in the law that they have to meet before they're able to do that. So they have to be investigating something criminal. They can't do it for like parking infractions or whatever, right? We're talking about criminal offenses. They also have to typically meet the criterion of investigative necessity. And so what is investigative necessity? Investigative necessity is we need to do this because other investigative tactics are just not sufficient.
Okay.
And they also have to have a basis to believe that they're going to get evidence, right? That there's some prospect, some realistic prospect of getting evidence about the offense. And often they combine these wiretap authorizations with other investigative techniques. So I think in the language they use in court, it's called stimulations.
Right.
We call it tickling the wires, right? Where they're trying to get people to talk on the phone so that they can hear what they're saying. And so they'll have like undercovers who like approach a subject or whatever and start talking to them about something and say, or they'll coordinate with like CP24 or whatever media releases at certain times so that people say, the cops are investigating this.
So they're talking on the phone about, oh, watch out, they're investigating you, like type shit?
Yeah. That's what, so they use the wiretaps with that. They'll often also almost always in these wiretap applications. So a Part 6 warrant to intercept someone's private communications is combined with other kinds of warrants. There's all kinds of warrants, right? You can get a warrant to search someone's house, search someone's car. You can get a tracking warrant so that the police can install a GPS device on your car. You can get a warrant to get information from telcos, from like Rogers or Bell or whatever, to be like, who are the people that who are the numbers that this person's called for the last 2 months.
Yeah.
And so they'll put all of these different kinds of warrants. They'll apply for like all of them together combined, and that's why these applications are massive. And they don't need to actually prove investigative necessity in certain kinds of investigations. Okay. One is criminal organization, and the other one is terrorism. Right. So if they're investigating a criminal organization, they don't need to establish investigative necessity. So they have to meet the other criteria.
Even what was the whole pizza spiel about? Like that wasn't even a telecommunications. They just contacted Pizza and they asked them about like, this person ordered pizza at this time. What name did they use? What address did it go to?
Yeah, what phone number did they call from?
Don't you have a reasonable expectation of privacy with a corporation?
So that is very interesting because what you're touching on is the other investigative tools that police are using combined with wiretap. So they're going to companies or business providers and trying to get some kind of corporate data, and they use them to either support their application for a wiretap or in conjunction with the wiretap. And sometimes they want to lead that evidence at trial. But that is an emerging area of the law that I think we have to be more and more concerned about.
Right.
Because more and more businesses are maintaining more and more data about their customers.
Yeah.
The police have a trove of information that they can access. And if they can go to any business and be like, I want to know your whole customer list. I want to know anyone who's bought this particular product. And what we see it in now, like, for example, in like hold up squad investigations, they'll identify that a particular tool was used in a break-in, right? Like a particular kind of drill or crowbar. They'll reach out to like all of the big box stores who sell this product, Home Depot, Rona, Lowe's, and whatever, and be like, yeah, find out for me to give us information about anyone who purchased or all of the purchase data associated with this particular product. Then they'll ask them for the security footage from that, and they'll be like, oh, okay, so this person bought this product. And they'll tie that to other investigative techniques. And so when we're talking about the you mentioned Pizza because we've been seeing this, and it was in the papers, I think, too, in the Star. Yeah. Pizza was just like straight up giving up.
Yeah. Like the cops would just ask for it and they'd be like, sure.
What orders came from this phone number?
Yeah.
What orders came from this address?
And then,
yeah. And at first glance, people are like, oh, like what's the big deal? But it does reveal some lifestyle choices about us, right?
Yeah.
Especially if you combine that with information from other private businesses. And the more and more consolidation we see with businesses, the more and more we see certain businesses being service providers, people that we rely on. And the big one I'm thinking about is Amazon, for example. Could you imagine if the police could just get all of your data from Amazon? Holy crap. And I'm pretty sure like Amazon's listening to us right now. I bought an Amazon TV. I'm sure it's spying on me because it's showing me ads and stuff. I'm like, you're listening to me, right? And so if Amazon could get just all of that or give the police all of that data without a warrant, scary. And so as businesses we're seeing more and more big companies get more and more data about us, and they have sophisticated ways of getting data about us that we don't even know that they're collecting. At a certain point, police not needing to get a warrant to get that information about us is pretty creepy, right?
Yeah.
Of
it's
course.
starting to border on mass surveillance, which I think is the biggest danger about wiretap investigations now. We are moving into an era. It started, I'd say, maybe 10, 15 years ago, we're really moving into an era of mass surveillance, and we need to, the public needs to know about it.
Right. I think one particular thing that the general public would be interested or shocked to find out is that you don't need to be suspected of committing a crime in order to be named in the warrant. Right. And you don't need to be an alleged criminal in order for you to be caught on a wire. Is that correct?
That's right.
Isn't the standard if you can assist the investigation?
So Ontario has, I think, one of the most lax standards in terms of allowing wiretap investigation or allowing wiretap authorizations to be granted. And BC, for example, has a different standard.
Yeah.
It's
will versus may?
Essentially, like, what is the degree of certainty that the police have that you're going to get evidence about a crime? And in Ontario, it's a pretty low standard. It's if we name this person may it assist the investigation as opposed to it will assist the investigation.
Right.
And if you think about what the courts have said about that is it's not just criminals, it's the people that the criminals talk to. It might assist the investigation, right?
Like their mothers and girlfriends.
So I think...
And the car rental agency that they deal with,
Yeah.
right? Like we're giving actual examples from the case law, right?
Right.
And so even if you don't know that you are talking to a criminal and you run Hertz or a budget, you could absolutely be named in the wiretap investigation because it might have investigative utility if they use these rental vehicles for committing crimes.
So
And
to
then-
that,
okay, sorry, go
to
ahead.
that end, if you can just kind of tell the listeners, what is a resort to line?
A resort to clause. Well, a resort to clause is so if you think of how police sort of add your phone to wiretap warrant, basically the police have to know who they are, whose communications they're trying to intercept. They can also name unknown persons. They'll call them like a John Doe 1 or whatever until they identify them. But also they will generally have their phone number. But they'll also have a resort to clause that says, I've named Sina and Kabir in this wiretap. A resort to clause is, but I also want to intercept the communications from any other phones that they resort to. Right. So this idea that like a lot of our clients have that like, if they just get a new phone, like whatever, that's going to change things. Like, no, like even your burners, if they have you named in an authorization and you are getting a new phone every couple of weeks, and really what's not funny, but when we see these wiretap investigations, we see how police get on the new lines. It's like usually because a person whose communications have been intercepted, they'll get like a new SIM card or a new phone or whatever, and then they'll text all of their like old contacts whose communications are being intercepted. And it's like, yo, it's so and so. This is my new line.
Yeah.
And then police are like, got another one, and they just add it. And so there are a lot of legal mechanisms in the wiretap warrants that allow the police to really keep an eye and keep intercepting communications of people that have been validly named in these authorizations.
So if you're a person of interest or target in a wiretap investigation, and then you subsequently speak to someone, that communication is intercepted, and police discovered that the person you're speaking to is now becoming a person of interest or target, what, if anything, can they do about that?
They'll do a rewrite. So typically in the big criminal organization investigations, we see two wires. So we see the first one, it's these big warrants that have wiretaps, tracking warrants, all kinds of stuff. They are valid generally for 60 days. And then they have the rewrite, which is the renewal, they call it too, the expansion, whatever. About 2 months in, a little bit earlier sometimes, they'll apply for the rewrite. And then they'll add everyone that they've discovered as part of, or whose communications are discovering criminal activities. And they'll add them to the warrant. And then sometimes, to their credit, they'll remove people who they're like, okay, we haven't heard anything from this person, or this phone's not working, or whatever. Like, this isn't really helping. We don't need them. But like, the cynic in me is like, they add a lot more. They add a lot more than they remove.
So can I ask you this? So say you're not initially a person of interest, not suspected of committing a crime, but you're a person of interest who they're intercepting your communications. What if then they hear you have committed a crime of some kind? Can they then use that to prosecute you in something different and apart from the actual wiretap investigation? Like, say, for example, you talk about stealing a chocolate bar on the wiretaps.
Yeah.
Can they then say, we heard this person talk about this on the wires, and use that wiretap evidence to charge?
Absolutely.
Yeah.
Absolutely. And they will build investigations, spin-off investigations off of successful wires.
Right. That's what happened to one of my clients who was faced with like very serious charges. He was a person of interest in a homicide investigation, and then they listened on, they did a resort to because he was changing numbers, and then they discovered, unrelated to their investigation, that he was running a drug operation. He was selling drugs out of town somewhere else, and that through the intercepts, they found out that he had been robbed at his drug house and that he was retrieving a firearm to go and seek revenge on the people who robbed him.
All allegedly.
That's right, yeah. And, they fully prosecuted all of that. They prosecuted him on the trafficking, on the firearm possession, everything.
Isn't that nuts, though? Like, you're a person that you really haven't... Because the thing is, man, like, if you listen to somebody's phone for long enough, you'll find something
absolutely
that's shady,
for sure.
Or maybe not illegal, but something that is, can be a bit...
well, even if you're not committing any criminal activities, you listen long enough, you're going to hear at least some embarrassing stuff.
Yeah, for sure.
Right? Yeah. Things that, we all have things that we've said on the phone that we wouldn't want other people listening to. It's a private communication, right? And we're entitled to that expectation of privacy. But I think the bigger point, Kabir, that you touch on is if you put a magnifying glass on anyone for long enough, they will have committed a crime. Like,
police included, I imagine.
Everyone. The only real difference in society in terms of who gets criminalized and who doesn't is scrutiny by the authorities, and really that ties to other factors: race, class, poverty, part of class, and other socioeconomic factors. So that is why I think we see, as criminal lawyers, we feel this injustice in the big wiretap investigations, because it's always, well, not always, but it's very, very often targeted towards like young, racialized urban communities. At least what we see in Toronto every year.
Absolutely.
The takedown is in like Regent Park or Vanali Walk or, Jane and Finch. Yeah. And then 5 or 6 years later, they'll go back to that same neighborhood and do another one. And they'll say, "Oh, I remember 6 years ago, we got all these people in these two buildings that were doing these dirty things, and then they're still up to no good, got out of prison, and they're still hanging out with these people." And the way they say, like, "Oh, we want to name this person because they have that we suspect that they're involved in criminal activity or it may assist the investigation." The things that they look at is like all the stupid like YouTube rap videos that people put up from their block, right? And they're like, "Oh, we saw this person in this video, so we think they're associated with this gang." Yeah. And people hanging out in the neighborhood with other people. So if you think about it, if you are just regular young dude, Jane and Finch, you live in one of those towers, or if you're one of the Dixon Road towers.
Hot zones.
Yeah, hot zones. And you are just like, you cannot escape your neighborhood. Like, I don't want to call them necessarily friends, but just the group of young people in your neighborhood. Yeah. You can't escape them. There's literally no way that you can just say, "Oh, I'm not associating with any of these people."
Yeah, because you live there.
You live there, and like there's a dynamic, a bit of a culture of like, I'm not going to like X this person just because they went to jail for some dirty shit that they did.
Right.
And so like, like if we're like chilling at the park and everyone's smoking a joint or whatever, like, and they're seen by police, the police are often going to draw those associations, say, "I saw this person hanging out with this person X times." Or what they do too is they go to the funerals, right? These are people that are not just like subjected to serious police surveillance, but extreme amounts of gun violence. And when their friends get killed and you go to a funeral, it's leading to more surveillance and more stronger odds that they're going to be named in a wiretap.
Yeah, like the police will go to a funeral and like take pictures and make videos.
They'll install cameras.
Yeah, they install cameras, and they'll just like, watch every single person that comes to the funeral. Like, dude, like someone died, right? But I guess for them, it's a great way for them to kind of exaggerate, people's involvement in certain crimes. Well, I at least that's what I think.
Well, I think the way that they frame it, and this is where our job comes in, the way that they frame it is like nefarious and criminal and this, that, and the other. And often we see all the time, like you guys know, that warrants are drafted in misleading ways.
Mm-hmm. Yeah.
And so it's our job to kind of try to discover that and show that to the court. But it's like an overwhelming endeavor to show that. But they will present things in nefarious ways when the flip side of the coin is really, these people who are targeted frequently over and over again really couldn't have done anything to avoid having their communications intercepted.
Right. And that's, I think, the biggest point for me is that this is obviously a very serious infringement on your privacy rights. And so when the test is investigative necessity, you would imagine that they would have to show that they've exhausted all other avenues of investigation before they resort to this.
But remember, investigative necessity doesn't apply where you're investigating a criminal organization. And this leads to another point. What the hell is a criminal organization?
Right, yeah.
It's really
It's like three
people who are involved with a certain amount of structure, and their main purpose is conducting like criminal activities. So like you're like 3 18-year-olds who get together and who are like, yo, we are the Titan Defence LLP crew. So they usually have 3-letter acronyms like BKT, RGP. I don't know. It's always like that. And really, I think the intent behind a lot of these like names and group names that they give themselves is really just a sense of like neighborhood solidarity. It's just a crew. It's kind of like a dumb thing that teenagers do.
Right.
Yeah.
And the police will often look at their YouTube videos and their rap videos, and will, get all of this information that they have from reports dating back to when they were youths and arrested for fighting or shoplifting or whatever, and show how connected these people are and say, this is the criminal organization that we are investigating. And then anyone that criminal organization is connected to all of a sudden becomes fair game. And they don't need to prove investigative necessity. So prove that there's a criminal organization, we're going to intercept all these communications, or show reasonable grounds that this is a criminal organization. And they're not going to Post Road or Forest Hill.
No,
right?
Of course not.
They're not going there to find criminal organizations.
Right.
So it's concerning that and like obviously too, like when you hear criminal organizations, I think most people think of like mafia, right?
Right.
Yeah, of course.
Cosa Nostra and those kind of criminal organizations. It's important for people to understand that the actual application of this criminal organization concept that we have in the law, it is not a fair or equal application based on our principles and values as Canadians, which is typically tends to be anti-discriminatory. I think there is a discriminatory practice in how police investigate criminal organizations.
Mm-hmm.
Yeah.
And it's it's impossible to prove, right? Like, as you as a defense lawyer, what are you going to do in court? Are you going to come into court and be like, Your Honor, this is discriminatory because they only targeted this black gang,
Right.
right?
Yeah.
Judge is going to say, okay, next argument, please, sir. Right? Like, because it's without doing, the work of 1,000 lawyers working full time for a month, you will never be able to show those kinds of trends and show those kinds of statistics. Our belief that it is the practice is discriminatory is really based on anecdotal experience that we have.
Right.
And our feelings and our experience from the criminal justice system. And there may be a little bit of bias in terms of how we experience it.
But I think it's probably true. Like,
I still think it's true too. I don't see a lot of white collar criminal org investigations.
Exactly.
Yeah.
That's
I don't.
exactly.
I don't think I've ever seen one, to be honest. That I can think of, at least.
And to think that they're not doing anything nefarious is absurd. Like,
yeah, of course.
that people in like Post Road or just affluent places are not committing any crimes ever is an absurd idea. And I've put that to officers a lot, especially with these like hot zones BS that they feed us. Right? And I'm like, Post Road is not a hot zone, is it? And I'd be like, I don't know. I don't patrol Post Road. I wonder why.
All right, so let's talk about something that interests me and bothers me quite a bit, and that's the police use of confidential informants, not only in wiretap investigations, but all search warrant related investigations. So the police often resort to investigative sources called CIs, or confidential informants, and they sometimes form a part of the investigation, and they form a part of the authorization. And I feel that they're relied on far too much. And not only that, there's no real authentic way to be able to challenge the information that a confidential informant gives, because there's something called informer privilege, right?
Yeah.
And it's like very high up there. And anyways, I'll have you talk about that.
Well, you call them confidential informants. I think most of your listeners probably just like call them snitches.
Yeah,
That's it.
exactly.
And you know, the law has long recognized that they're an effective tool for law enforcement. And basically, police are entitled to rely on information from snitches. But the law also recognizes that in order for the information to be really good enough to justify a warrant, it has to be compelling, credible, and corroborated. And the 3 C's, you guys know that, right? That's what we call it. And so what that means is the police should make sure that the information is compelling. It really tells you something that is believable and fairly specific. It should be credible, no wild goose chase that they're going to send you on. And it has to be corroborated. You can't just take it at face value. You have to take some steps to see if what they're saying lines up with what you can find out through other means. And corroboration has to go to material aspects of the information. So it can't be like, yo, Kabir is selling drugs. And he, by the way, I know Kabir has a really nice pair of sunglasses, right? Like, no, it has to be relating to the offense. Mm-hmm. So they will be used to justify warrants, to sustain warrants. And our access to, when I say our, the defense's access to information about these tips is really limited because confidential informer privilege within the circle of privilege, so within, you know, law enforcement or anyone who knows about who the informant is basically absolute. So they cannot reveal the identity of the informant. And the reason is snitches get stitches, right? The danger that is posed to the life and health of an informant if their identity is revealed is significant. And we know that. So there's this balance between trying to use snitches to get valuable information and trying to give defendants the ability to challenge the lawfulness of the authorization or the arrest or whatever it is. So what you're saying is you don't think there's good balance in that process, right, Kabir?
Yeah, that's exactly what I'm saying. Because this is my issue with the entire confidential informant situation. There is no way to find out if a cop just made it up, right? Like, that's the thing.
A Fuzzy Dunlop, right? Do you guys know Fuzzy Dunlop?
No, what's that?
You guys haven't watched The Wire. This is why I love The Wire. So in The Wire, you remember there's this episode where they like make up a confidential informant. They take a picture of this guy and they register him. And they had installed the cop. And the cop had installed got the information by installing a camera illegally somewhere in a tennis ball. And so he like made up this snitch, the CI, registered him and named him Fuzzy Dunlop, the tennis ball, right? And that's in The Wire. And so what you're talking about is how do we know they're not just like making up a CI, and they're just using information that they obtained illegally and attributing it to a CI because the defense is really never going to be able to find out who the CI is. That is, I think, a real and legitimate concern that you have, Kabir.
But I don't understand. So if let's say you're challenging The Wire and the ITO in court, doesn't the judge get an unredacted copy of all the material to kind of decipher what should and should not be disclosed to the defense? So shouldn't the law enforcement, you're nodding your head, yes, shouldn't the law enforcement in that instance think to themselves that if it does go that far, it becomes a potential possibility for a judge to find out that we made this shit up and then the investigation is just bunk entirely?
But what is the process in which the judge reviews the unredacted information? And is that process meaningful review of law enforcement actions? Right? And I don't think so, because typically we rely on the adversarial system, right? Defense makes points, prosecutors make points, and the judge is kind of there to referee. But when it comes to the process by which we scrutinize information from informants, it is difficult for the judge to engage in that adversarial system because the defense can't be in on the privilege.
Right.
And beyond the challenges with the amount of resources that are needed to really look into whether or not the information's compelling, credible, or corroborated, there are also ways for the police to abuse the confidential informant system, not disclosing the true extent of the consideration that they get, right? Like, so snitches, for example, are allowed to get off on charges or to get money or whatever. And how do you know that the police are actually disclosing the extent of the consideration that they're getting? How do you know that they're being honest about how much money they're giving them? There's a whole, for example, in Toronto, there's a whole policy on source management, how you deal with confidential informants. And there are very strict rules on how you deal with them. How many lawyers in every single case involving an informant go to the policy and make sure that the policy was complied with to a T, to make sure those safeguards are in place? Few, I think. Very few. And this is part of the exhaustion that we feel being defense lawyers. It feels like an insurmountable task to actually do that in your case. It's very discouraging because challenging the use of confidential informants is very, very difficult, and it almost feels like you're never gonna forget it. You're never gonna get anywhere with a challenge.
So it's basically when a judge is, say, reviewing the unredacted application, the ITO, to obtain the authorization, all the reviewing is just paper, right? It's not like they bring the confidential informant to court and then that they testify in front of a judge, even in the absence of a defense lawyer, right? So everything that is being given to the judge, there's no real way to confirm how truthful or reliable it is, or even if it's true at all, if it exists,
or even if they've been caught lying to the police previously in a prior case.
Well, you make a good point. Typically, the confidential informant packages that are given to the judge for review will include the informant's criminal record. Now, what do we know about criminal records? We know that criminal records very often don't disclose the true nature and extent of a person's prior criminal activities,
of course,
even that the police are aware of.
Just convictions.
Exactly.
Yeah.
So where police officers have a relationship with CI, and the CI commits a crime, and the police believe that the CI is a very valuable asset in the field, there is an incentive to use their discretion, which police have and are allowed to use, to not lay charges, not proceed with a prosecution. And that, I think, can lead to minimizing the true nature and extent of a confidential informant's reliability problems.
They don't want to sully the CI, right?
Exactly. The worse a confidential informant's criminal record is, the less reliable they can seem as a source when presented to the court. Right. So there's all these really subtle ways that these relationships between police and informants are not getting scrutinized properly by the courts, and really the defense has no way of challenging their reliability. There is supposed to be a safeguard. The law is supposed to have this procedure, right? There's that case, Garofoli from 1988, a 6-step procedure to seeing if you can challenge the warrant in court and the extent to which the prosecution can rely on redacted information to sustain a warrant. So years ago, they never used to rely on what was behind the black, right? In the sense that what was redacted, what the defense didn't have access to, prosecutors would not try to sustain a warrant, to say the warrant should be upheld based on the information the defense can't see, right? And some years ago, that changed. Authorities started relying on what we call step 6 more and more, and the courts have sanctioned it. And I think that is a real problem. I really do think that there is a constitutional problem with step 6 of Garofoli. And if you talk to experts in the field, they will say, well, Garofoli was released pre-Stinchcomb, before the and Stinchcomb, for listeners who don't know, it's the case that constitutionalized the right to disclosure. Americans call it Brady disclosure. Basically, anything that's not clearly irrelevant that the prosecutors have in their possession and the police have, they have to give to you. And so Stinchcombe was this massive a case that massively changed the criminal law in Canada, and it was seen as this this enlightened decision that gave the defense full answer in defense. It gave them the ability to really defend themselves.
A fighting chance, basically.
Exactly. And so shouldn't we revisit the six-step procedure in Garofoli, since it was decided before the Supreme Court gave us this enlightened view on procedural rights of defendants? And I think so. We'll see where the courts go with it.
Has any other wiretap case gone to the Supreme Court after Garofoli?
Oh yeah. But the Garofoli procedure isn't just for wiretaps; it's for any kind of warrant. But we've had wiretap investigations go to the Supreme Court, and the CI system has been scrutinized by the Supreme Court in a certain amount of cases. But
I can't. To me, especially the CI issue it's as clear a day as a conflict of interest gets. Not just on the part of the police, as you mentioned, but on the part of the CI as well, right? How many times does the CI basically, let's say, makes some shit up to appease their handler or the police in order to kind of avoid their own criminality? And lo and behold, what they say to the police leads to something else that ends up being true, aside from what they had given their handler to begin with.
Or think about this. What if a CI who gets pinched on whatever, let's say some relatively minor drug charges, they get pinched on, let's say, half an ounce of cocaine, and the police either have experience with them as a CI or they don't, but they can flip the guy and turn him into a CI. And they say, well, give us something good, because we need something good if we're going to let you walk on these charges, if we're going to decide to exercise our discretion to not charge you. And what's good? Guns. Police love finding guns. Mm-hmm. And what if Mr. Cocaine dealer turned snitch knows that he has a gun that he's been keeping at his buddy's house? Right? Huge incentive for him to set someone up, right? And we don't talk about this in the law, I think, enough. The incentive that CIs have to essentially set people up and plant evidence where they know them. And the police will say, oh, this is a CI, he's been tested once before and it was reliable, it led to the discovery of evidence. And, he knows this guy very well, probably because he's associated with him in criminal activities and is able to tell the police details about his criminal record.
I think that's when your client needs to testify.
Sorry?
I think that's when your client needs to testify.
I've been set up. It wasn't mine. And
the judge is going to be like, yeah, sure, buddy.
Or a jury like, oh yeah, sure, buddy. And what are you able to tell the jury about the CI, right? If you don't know who the snitch was, and there's no way for you to really find out because informant privilege is sacrosanct. Yeah. And police found a gun in your basement.
You don't even know you've been set up by the person who put it there. That's fucked up.
Yeah. And let me ask you this, Sherif.
But there are cases about that, right? Where CI, like there was that case out in Hamilton. Do you guys remember that? Like a CI had planted a gun on someone. Yeah. This was a few years ago. But like it happens. It's not like, what I'm saying is it's not unheard of for CIs to set people up. And the incentives are there, right? Getting off charges.
That's a huge one. Getting paid. Sometimes they get paid cash.
Yeah, especially if they're drug addicts, right? If they'll
say anything, right?
Yeah. So
can I ask you this, Sherif?
Yeah.
So oftentimes when we think of confidential informant, we think of a confidential informant as a kind of person who's willingly going to the police and has some agreement or arrangement with the police.
Yeah.
Can police take information that they just, for example, overheard from someone, or say they didn't tell the person we're going to use you as a CI, but the person just told them something? Can they be labeled a confidential informant just through information received by the police?
There is a process for registering confidential informants, and every police service should follow that process.
That's a carded informant, right?
Exactly. But there are many instances in the case law where sources of information are portrayed as confidential informants, registered confidential informants, or whatever you want to call it. And turns out there's not. There's like a case where it was a police officer who wanted to remain anonymous and was portrayed as an informant. And it's like, what? This is a narc. What are you talking about?
So that's actually one of the things I wanted to ask you about. This concept of kind of bridging the gap or distinguishing between a confidential informant and a state actor.
Yeah.
And how does that come up, and what the issues are that come up with it?
So, a confidential informant should be a registered informant who's told certain things by the police. Like, we're not telling you to engage in any criminal activity. We're not directing you to do this. You understand that if you don't provide us reliable information, you don't get the consideration, right? So those are things that are supposed to be used to safeguard the reliability of the information and the process of using informants. Where they become, when you say state actors, like I'm thinking about agents, right?
Right.
Where, let's say, an informant says, I have information about a guy who has a gun, but I don't know where he keeps it. I don't know this and I don't know that. And, the natural human tendency, I think, for the police will be, well, find out for us, right?
Yeah.
And where they do direct them to do something, that's not an informant anymore, right? That's an agent.
Right.
That's an undercover operative that you're sending into the
and
field.
then you're entitled to their name and everything else, right? Like all the regular disclosure you'd get for someone who's
if it's an agent, it's not an informant. So for us as defense lawyers, what does that mean? How do we discover if someone's an agent? So the case law says that there's some indications that you can look at. If you can see in the warrant, and sometimes it's redacted, you can't really tell, but you can ask the judge to look behind what's redacted. If you can see that there's like a relationship with the informant and the police, and they're giving more and more information throughout the investigation, it might give a basis to believe that, hey, this is actually someone who's being directed by the police to get this information, especially if it's constant, updated information in a short period of time, right? And so as defense lawyers, we have to be able to try to see these hints of agency, and you apply to ask the court to say, hey, look, we think this person's an agent. There has to be some kind of review mechanism that we can engage in. And so you ask the court to look behind the black, behind the redacted. They can have an in-camera hearing, like a secret hearing, where the judge will cross-examine the handler. There's no set procedure in it. There's a case called Sandu that went to the court.
I didn't know about this at all.
Yeah.
Wow.
And I've had a case where we took that approach. We thought that the person was an agent. In the course of that, the Crown ended up staying the charges. But I think it's something that we need to explore more and more, because I do think that that police are not, based on my experience, what I see, they're not following the source management policies to a T like they should be. There's supposed to be safeguards, right? Like, you should never have only one officer speaking to the informant alone, right? There should always be two people, a handler and another officer. That's in the policy. But how are the handlers and the informants actually talking, though? Like us, they're texting, they're WhatsApping, right? They're not actually, I don't think they're following the policy. And I don't think they're actually making sure that they don't subconsciously turn them into agents. I don't know how frequent this is, but I think it's happening more than we know.
But the challenge of it is such an uphill battle. Like, to figure that out, or like to even for a judge, even in a circumstance like you just mentioned, to be able to get out of an officer that they actually asked the person to go and do something and get more information.
Yeah, they're never going to admit that.
So rare,
They're not going to admit that.
Right. Or how are we ever going to get disclosure of the text message exchanges between, a handler and a CI? No.
We're barely able to get like surveillance footage that's seized on the day of a crime, guys. Right?
Yeah, basically.
Like seriously.
It takes 8 months sometimes to get a video from them about
sometimes more, and they'll deny that the disclosure exists. This is what drives me crazy. We have these lofty principles that the courts are like, oh, but you're entitled to disclosure, and how disconnected that is from the reality on the ground of what the defense is getting in terms of disclosure. It's a massive disconnect. We don't get full disclosure like we're constitutionally entitled to on a regular basis, because there aren't enough checks and balances, and because we're like, I hate to say it, guys, but we're weak and pathetic, right? Defense lawyers are weak and pathetic, and I say this with great respect to Titan LLP. And I wanted to say, guys, by the way, I love the name Titan LLP, even though I think it's a little bit cute. But I see what you guys try to do with that, which is project an image of strength, which is in the face of how weak we actually are. No, we will be strong. We will fight for the poor, the weaker party, and we will be their Titan. And
Thanks,
so
man.
it's true.
That was the sentiment behind.
I know you guys. I can tell, and you guys are truly Titans in the defense bar. So I'm glad that you guys try to project that image, because clients also should feel that they have strong fighters fighting for them. But the reality is, the system is a grind.
Yeah.
I think it's, we're just seen as people who are making things difficult for the system. That's what criminal defense lawyers are.
Certainly from the perspective of, crown attorneys and judges.
They just want to push as much or as many people through the system as possible, as quickly and efficiently as possible. And a defense lawyer gets up and causes a stink over something. All they're doing is making things difficult.
Here's the thing, though.
I don't like that.
I understand that perspective, because I don't agree with it, but I understand it. Because if everyone practiced the way that we do, the system would crumble. There's no way, because there's such a low percentage of cases that are going to trial and that are being litigated, that if everyone decided to fight tooth and nail for every case, the system would just crumble. It wouldn't be able to hold itself.
We've known this for years. If all defense lawyers agreed to just set trial dates on everything and not plead their clients guilty, obviously with instructions from their clients, then the system would actually grind to a halt.
Yeah.
So, I don't think the response is to turn our criminal justice system into a conveyor belt machine where cases are processed. I think the right approach is to massively divest from prosecutions, right? To cut the number of prosecutions that we have down a ton. But you're never going to have politicians who run on that platform, right? That we need to stop charging so many people with crimes.
Yeah.
The system, and this is, again, going back to the connection between capitalism and the criminal justice system. The system has all of these tentacles, the carceral industrial complex that is built on lots of prosecutions. How do you justify $1 billion jail, right? How do you justify the Toronto South Detention Center?
Yeah.
We need to fill it up with bodies. We need to show the public that we're prosecuting people. We need to make sure that these security companies and the lobbyists for them are happy. And that's by awarding these contracts to, security companies. It's by the police services boards approving
budget.
massive budgets for police services. So
who are very much threatened by concepts of defund the police, which is at its core and root what it is we're talking about here, right? You got to take away from putting people in jail and having that as the knee-jerk reaction and making criminals out of them, and start reducing the number of people you're charging with criminal offenses because you recognize that they are not necessarily criminal.
Well, what is the social utility of the criminal justice system in the first place, right? Is to make sure that we have public safety.
Mm-hmm.
It's supposed to achieve the objectives of denunciation and deterrence, right? We're trying to deter crime and keep people safe.
But also rehabilitation is supposed to be.
It's supposed to be rehabilitation. But if those are our objectives, are we really making society safer if we criminalize a large portion of society, a significant amount of Canadians? If we have about, I think, 4 million people in Canada who have criminal records, that's more than 10%.
Wow.
Yeah.
That is wild if you think about how marginalizing and ostracizing having a criminal record is in terms of what it does for you, in terms of your ability to be gainfully employed,
right,
to have good relationships with people. And in today's era, it's even more dangerous, I think, because of the advent of the internet and in how fast data and information is shared. Like back in the day, if you had a criminal record, like, in the 70s, like odds are most people, wouldn't find out about it. But now, with the press releases, you don't even need to have a criminal record.
Exactly.
You just charge those offenses.
And your name is in the newspaper.
And
forever.
That's it. And that's it. And
doesn't matter if you're acquitted or not after.
It's not updated.
The banks will stop dealing with you. You will not get employed.
I travel to the U.S.
Sudden, residential landlords are looking you up before they approve your rental agreement. It has the implications of it are grave.
So even if you're a guilty person, let's say you committed a criminal offense for whatever reason, and you get that criminal record, and all of those things happen to you, you are socially ostracized in that way. does that make society safer? Is that preventing crime?
No.
Is that deterring crime? And then let's say you're innocent and you've been wrongfully convicted, which we know happens.
Right.
Does that make society safer? Is that fair? Does that deter crime? We're hurting ourselves, right? And the best example is to look at the extreme example of the United States, right? Yeah. Did their mass incarceration exercise that they really entered into with the sentencing guidelines in the 80s and 90s when they started throwing people in jail for these crazy 100-year sentences or whatever, did that make America safer? And now the response is, instead of sort of defunding or divesting, it's this gross cycle of, oh, well, no, now we have all of these crimes and these criminals.
We need to militarize
the police. And it's like,
they're cruising on the street in tanks and body armor.
Is that what
machine guns?
Is that what a free society is? So I'm originally from Egypt, and people that come from third world countries that have military dictatorships in place, or societies that we know are not free, will recognize certain symbols of an oppressive country. And for me, that is when I see guards walking around in civilian neighborhoods with machine guns. Yeah. That for me, I think is terrifying. That's not a free country. Oh. And that's where we move to. Like, even when I see officers here, like downtown, walking around with these big, massive machine guns and the war gear, it's like, is that a free and democratic society? It's like, come on, guys, we're supposed to be a liberal democracy. Right. There is a connection between freedom and mass incarceration that we need to recognize, and say that mass incarceration poses an existential threat to us as free Western liberal societies.
Wow, man.
Deep, man.
That's deep, bro. Look at this guy. Huh?
I think we can go on this tangent forever. I love it. I love it. I want to briefly talk about, well, first of all, I want to briefly talk about, you talked about Garofoli and the 6 steps. I know I'm asking you a super, super difficult task here, but could you just simplify what that is for our listeners who are not lawyers and what that means?
Yes. So there are 6 steps to challenge a warrant under Garofoli. And those steps involve, and I might get the first one wrong, unsealing the packet, which is basically getting the warrant applications are usually sealed, so no one has access to them. So it's unsealing the packet. It is providing essentially summaries or providing disclosure to the defense. And the defense often in steps 3 and 4 go through this exercise of saying, I want more, redact less. And so in court, we argue with the Crowns. The Crowns will have sort of these secret conversations with the judge in different ways. So some of it, sometimes it's in writing, sometimes it's in camera, where they say, Your Honor, this is why I can't give the defense more information. This is why it'll tend to identify the informant. Right. And so there's that process. And then step 5 is, okay, can the warrant be upheld? Right. Mm-hmm. And there's a lot of different ways of challenging a warrant. You try to prove that, the person who applied for the warrant lied and right. misled the court. But also a warrant can be challenged based on, Your Honor, this warrant couldn't have issued. Right. If you look at what's not behind the black, so if you look at what's left from what's redacted, the facial attack, right? So on the face of the document, this doesn't meet the legal test that's required for the issuance of the warrant. It should be quashed. And then step 6 is, because back in the day, they used to only go to step 5. This is what I'm talking about. Step 6 is fine. If we get past step 5 for the defense, that means the warrant should be quashed because what we see on its face isn't enough to justify the issuance of the warrant. Step 6 is Crown asks the court, the prosecutor asks the judge to go behind the black, to look behind the redactions and see if the warrant could have issued. And you can only really rely on step 6 if you have procedural fairness. And that means if the defense has enough information, maybe not to know exactly what's behind the black, but enough information that allows you to make arguments to the court to say, this is why even what you have behind the black isn't enough to sustain the warrant. But I think it's very difficult to actually meaningfully engage in a warrant challenge process when the summaries that we have about what's behind the black really don't give us much information at all. And that's on top of the whole question of, is it true?
Right.
Is it reliable?
Yeah.
And I guess the next question I have is that in terms of when you talk about the packet and you also talk about the redacted warrant itself, what is it specifically that the issuing judge, the judge who's authorizing the warrant and putting their signature on it, what do they see?
No, they have unredacted.
Right. But do they have access to the packet, or is that just something that's kind of held in abeyance in case there's a challenge? Like, doesn't the packet include, for example, notes of a handler, other police notes who are involved, what
Pictures or something like that.
things like that?
So no, typically the sealed packet includes what we call the appendices to the ITO. So the warrant application is called an ITO, information to obtain. It's a sworn document. The police officer swears. They say, this is my application. They'll have appendices, so documents. Appendix A, this is what I'm searching for. Appendix B, these are my grounds. Appendix C, these are the locations to be searched or whatever. Appendix D, this is information about the confidential informants, right? And Appendix D will have like a summary written by the officer, the affiant, the person who applies for it. But it's the person who swears the application often isn't the handler, right? It's not the person that has direct communications with the informants. And sometimes they'll include the informant's criminal record that they say, oh, I got this from the affiant or whatever. But they will not include what we call source documents. They don't include every investigative report that they have access to. And that's where the defense often challenges them. We say, what are the source documents that you use to apply for this warrant? Mm-hmm. And we compare the source documents to the warrant application to see, hey, did they say this investigation led to the discovery of drugs when in fact it didn't? So that's the exercise that we often use to sort of challenge the warrants. They're getting a lot better at not misrepresenting source documents. Apparently, if you talk to old timers, they used to misrepresent stuff that was in source documents all the time, and lawyers had a field day. But law enforcement gets smarter and smarter and knows. And it's actually good for the development of the rule of law. Which
all you gotta do is not lie.
Yeah,
right.
And do your job properly.
And do your job properly. Like I remember I used to get warrants where the officer would list all of the times my client's been charged, but not note that they were acquitted every single time.
Yeah.
Right. Like that's misleading. It's not necessarily untrue because he was charged all those times, but he got off.
But what's the inference is asking to be drawn from that? What is being charged doesn't mean anything.
Exactly. It's just to sully the person's reputation and see this guy's a criminal.
Yeah, and the courts have recognized that is misleading. So the leading case on what we call subversion of the pre-authorization process from Ontario is a case called Periniak. And that was a case where a current judge on the Superior Court was the lawyer who had argued it at trial, where the affiant and this was for a grow up, by the way. He was looking for. So this is we're going back in time. They're applying to find a grow up. The affiant had done exactly that. Said this guy he was charged with all of these offenses, and then the lawyer for him was like, I want to cross-examine. They have to apply to cross-examine the affiant. Right. Said, I want to cross-examine him on this. This is misleading. And then the affiant in that case spontaneously apologized. He's like, oh, I'm sorry for not mentioning that he was convicted. And the judge said it was a disingenuous apology. It's BS. And I want to hear more submissions on whether or not the warrant should be quashed, even if there were sufficient grounds for its issuance. And so now we have this doctrine of subversion that we recognize in Ontario. Some other provinces don't really believe in it, like BC doesn't believe in it, which is even if you have enough info to get a warrant, but if the person who applied for it lied about something else, that is so bad that we're not going to allow the police to benefit from the fruits of the warrant. I agree.
You don't know what else they lied about, right? Like if they're showing a willingness to lie or even bend the truth, then that should be problematic enough to sully the reputation.
They're careless with the truth,
exactly,
right? And that's unacceptable to me, at least.
Leaving aside whether or not you can't rely on the rest of the warrant, there should be a deterrent effect on law enforcement to lie, right? Like if there is if they've done something wrong in the warrant application process, and I think this should apply across the board to all charter rights. Right. Like we should become the courts should, and the courts disagree with us because they say the purpose of excluding evidence isn't to punish the police, right? The purpose of Section 24.2 of the Charter, which is
Well, it should be though. I mean,
that's what I'm saying.
To send a message.
It should be to send a message. We should be sending a message that the courts are gonna tank prosecutions where you don't respect people's rights to a T.
Yeah. Otherwise, you have a police state. That's what it is.
Well, it leads to perverse incentives.
Yeah.
I think in terms of wiretaps in general and Garofoli applications, I think this is one of my favorite areas of law, but also one of the most complicated. It's super difficult, and they don't get challenged enough because the resources that are required and the legalese know-how that are required behind it are so grand, and it's so big. And the point that was kind of driven home for me was I watched one of the Garofoli applications that you were counsel on, and when you were, I think it was you or somebody else involved in the application, was cross-examining the affiant. So you guys got lead to cross-examine the affiant. It came to light that the last time she had testified, first of all, that she had sworn thousands of ITOs to get a warrant, but the last time she testified was a decade ago.
Yeah.
Right? Because nobody is challenging them.
Yeah.
Right.
I mean, they make it so it's basically impossible for you to challenge. That's how it's structured.
That's it.
So
right?
one, you're not going to challenge a warrant if you don't have a lawyer, because you're not going to know how.
Of course.
If you're lucky enough to have a lawyer, do you have a good enough lawyer who knows how to challenge the warrants? And I don't say that to disparage lawyers or criminal defense lawyers.
Right.
But the truth is, when I say good enough, I mean like equipped.
Yes.
Yeah.
Do you have a
With
lawyer
the legal
who's
knowledge to know
not
how
just
to do
legal
it.
knowledge, with the time?
Yeah, that's
right.
true.
The time, the will. Do you and that's the other thing. Is this a privately paid lawyer or legal aid?
Right.
And we think all privately paid lawyers are going to work harder because they have more money. But if you think about how much money should go to the defense or the challenge of a warrant, do you know legal aid will generally, for these massive wires, fund 2 or 3 lawyers to challenge the warrant, and there are literally hundreds of officers involved in the investigation.
Yes.
Right? And 2 or 3 crowns.
And the issue
it's David and Goliath.
That's it. And we've touched upon this in terms of discoverability is a massive issue. How many times, and I'm sure this was more so the case back in the day, how many times do they do an investigation of a project matter, 70 people are arrested, and your client is a speck, a dot of what's happened in this entire investigation, and you're getting hard drive after hard drive after hard drive of disclosure and evidence, and the Crown isn't pointing to exactly what portion of that is relevant to your client, and worse yet, you still as a lawyer have to do your due diligence to make sure your client isn't showing up elsewhere that's, extricating them from this investigation.
They get you a disorganized data dump as an intimidation tactic.
Yes.
1. 2, the bigger these investigations are, the more difficult they are to challenge.
Yeah.
The more people are at risk of having their privacy invaded.
Yes.
Right?
Yes.
So where the stakes are higher, you have less meaningful ability to challenge.
Yes.
And that's where we're going. The wiretaps getting bigger and bigger and bigger means that we have less serious oversight. And this is what I was talking about, it being disheartening. I used to love these, right? And I still kind of do.
Yeah.
But it is disheartening and difficult and challenging to really attack a wire. I'm not being hysterical when I say there's a real risk that we're moving into an era of mass surveillance.
Absolutely.
Right?
And I think, one thing that I've always appreciated about the way you practice criminal law is that I tell everyone that Sherif is giddy about criminal law. You love it. And I hate to, hear you say that, because as if I was ever a client, I would want to have you in my corner. And it sucks to hear, because
it might happen one day.
It absolutely could.
But I'm going to charge you top dollar.
I think one thing that's really, really disconcerting is how easily you can access someone's private information in this day and age, and how difficult it is to challenge, any violation of that expectation of privacy.
Well, the expectation of privacy that we talk about when we talk about it in the criminal defense or the criminal law world, a reasonable expectation of privacy. What is that? It's a normative concept. What does that mean? It means that there are values imbued in the definition of what you have a reasonable expectation of privacy over. But it's also vis-a-vis the state. What the cases talk about, the seminal cases, and still to this day what the Supreme Court says is a reasonable expectation of privacy is it really has to do with your right to be left alone by the state. So your private information that you might not want your law partner, your spouse, your friends to access. Right. If they accessed it, you would feel a sinking feeling in your heart and a betrayal. If the state accesses it, it's way more serious. And yet we have less oversight over the state invading our privacy compared to the, I think, expectations that we have in the private law world, right? We have torts, intrusion upon seclusion. We sue people for hacking into people's data, right? In the private world, we view, or in the civilian world, we view our privacy interests as, I think, more deserving of legal protection because the courts, I think, enforce those privacy interests more. And that's where you're equal, where you have equal parties, right?
Yeah.
But when it comes to the state, because of the interest in investigating and investigating crimes and enforcing the criminal law, our society just isn't there in terms of really protecting having robust safeguards over our privacy rights. I don't think we're there. And I think it's because the public is really misinformed. I don't think they, like, do you think listeners to your show know that technology even exists today, that the police can literally install an app on your phone, turn it into a hot mic? Like, and we probably only found out about that technology existing years after they started using it or it came out.
Sure. They've probably been
right?
using it for, decades.
How often is it that we see these articles in the Star or whatever, like Toronto Police denies using Clairview AI. This is the artificial intelligence, the facial recognition software. And it's like, oh yeah, actually they did kind of have it and we're sorry about that, right? Like, are these one-off anecdotal incidents where it's, a scandal for a day or two, or is there way more beneath the surface that we don't know about? I think it's the latter. Yeah. Maybe that's just like the paranoid
we're
defense
all like
lawyer
that.
and me. We're all kind of like that.
Yeah, because when you hear about this stuff and you deal with it day to day, you can't help but to become a bit of a conspiracy nut. Like I'm super paranoid,
and we're justified in that. And what's crazy is, you say you're like kind of disappointed that you hear me saying I'm a bit disheartened. Like, this is what the job does to us, right? Yeah. The job. Are we allowed to swear?
Yeah.
The job really, really fucks with your head.
Yeah.
Right? It really fucks with your head.
Yeah.
And we're losing people. We are losing so many defense lawyers to join the Crown or just leave the profession. And what we're not talking about is how the system operates. It's not designed in a way, but it operates in a way to really fuck with each and every one of our heads, our livelihoods, right? As much as people think we make a ton of money, like,
it's not true. Yeah,
it's not true. It's okay.
Yeah.
Good living, not like a corporate lawyer.
Yeah, totally.
But
the connection,
it's fun.
Yeah,
so
totally.
It's a really tough gig, man. It really is.
Yeah, and you say I'm always giddy about the law. True, but sometimes I question: Can I do this for another 30 years, man? Can I? Holy shit! It's exhausting. Holy shit!
It's like your brain is always thinking about something. Like in this job, there's never a moment when like I'm not thinking about a file.
Yeah,
and it really takes your life over. And that's not even like when you're in a trial or something. This is like on a day-to-day basis. When I'm in a trial, I literally cannot even go to the washroom without thinking about my case like nonstop.
It's a labor of love. It really is a labor of love, because then you question your life choices too, right? You're like, the sacrifices I'm making here on a Sunday, not being with my family, getting, nerding out over wiretap investigations. This
is fun. This is actually relaxing for me compared to the stress of thinking about individual clients. And the other thing is too, it's not just like the stress of the gig, but where we fit into society now and how technology impacts us. It's like we're always on. every single defense lawyer is like always checking their phone for the next email, the next message from a client. And we can't even get away from our clients, right?
No.
Our clients will all find a way to text message us and find us on like, at the most inopportune times. Like we'll call you on like a Saturday night at 11 p.m. and be like, oh, it's really important. It's really urgent. And it's like, when's my bail variation coming through? And it's like, it's like, can't I have a moment, just a moment of peace? Yeah.
For sure.
Yeah. But it is fun.
Should we,
Yeah. Sherif, man, it's been a pleasure having you.
Guys. Thank you
so
much.
Not only are you a phenomenal lawyer, highly intelligent, very articulate, you're also a good friend of mine and a good friend of Sina's.
For sure.
Yeah.
And I appreciate you coming today, and I appreciate you, doing your job with as much heart and soul as you put into it. And
keep at it, man. We can't lose you. You're
he's not going anywhere.
You're
for a
the
while.
ambassador to the underdog, man.
Yeah.
I don't know about that. I think the ambassador I'd like is a Titan. So I appreciate you guys. you guys are like, I listen to I'm probably your most frequent listener to this podcast. So I'm glad you guys had me on
one at least.
That's it, exactly.
So I'm glad you guys are doing this. It was a lot of fun, and I appreciate you guys. Thank you.
Yeah, I can't wait to have you back, man.
Thanks, guys. Thank you.
Yeah. Talk about some other sexy topics when you're
absolutely. Happy to anytime, guys.
All right.
Thank you.
This is Justice Redefined and presented to you by Titan Defense. And peace out, everyone.
We're out.
Until next time.